The question is, if you're the buyer, what exceptions can you get removed from the policy so that your policy will cover those types of claims? First, there's the standard exceptions. These include things like rights of parties in possession under unrecorded leases, liens that are placed on the property between the date of the commitment and the date of closing, easements that are not recorded, and matters that would be disclosed by an accurate survey or an inspection of the property. The title company should be able to remove or at least limit almost all of these standard exceptions with an affidavit from the seller and approval of a survey. Second, a lot of times there are easements, restrictions, or reservations that do not actually affect the property that you're buying. The surveyor who prepares the new survey or updates the existing survey should be able to determine which of these encumbrances do and do not affect the property, and typically these findings are shown on the survey. Once the title company receives the survey, they should be able to remove any easements, restrictions, or reservations that the surveyor finds do not affect the property. Third and lastly, there may be some exceptions that were applicable to the property in the past, but they no longer affect the property because they've either been abandoned or they've expired based on their terms or based on state law. The title company should be able to remove these exceptions with appropriate documentation, such as affidavits, terminations, or releases. For example, the title company should remove a recorded memorandum of lease for a tenant whose lease is expired with appropriate documentation, such as an affidavit or a termination of the lease. Other restrictions or reservations contained in deeds or CC&Rs sometimes have a time limit expressly set forth in those documents, and sometimes state laws place a statutory limitation on how long restrictions or reservations can be in place. As another example, I was able to get a mineral reservation and other restrictions removed from the title policy exceptions for a client purchasing a property in Michigan because the reservation and restriction both expired under Michigan's Marketable Record Title Act and other law limiting the duration of mineral reservations. In all, removing these types of exceptions from the title policy protects you from unexpected and costly claims from others claiming some right in your property, which is why it's important to review the title commitment and the recorded documents affecting the property.